All right, we are good to go. So we'll officially call the case of Marks versus Sunny's Rooftop Bar to order. My name is Judge Jeff Blank. And if we have new scoring judges who haven't been scoring the previous rounds, please look to the two buttons on the lower left of your screen and turn off your audio and video. These should remain off until the trial ends, when we'll have some brief comments. And at that time, you can turn on your video and audio. Also, you should have your video set to hide all non-video participants. This means the only people on the screen right now should be the advocates and myself. With that, can we please have our attorneys state their appearances for the record?
On behalf of the estate of Jessica Marks, my name is Annie Zhang, and I am joined by my second chair, Lindsay.
Excellent. Oh, please introduce yourself.
Sorry, Your Honor. Good afternoon, Your Honor.
Good afternoon. All right, and how about for defense? Can we have the defense attorneys please state their appearances for the record?
Good afternoon, Your Honor. My name is Reed Smith, and I'm representing the defendant today, Sunny's Rooftop Bar. Now, today I'll be joined by my co-counsel, Mr. Judd Bueno, but you won't see or hear from Mr. Bueno today. He'll be off screen running the technology and doing his best to keep us on track.
That is awesome. We've had two good trials so far with limited little glitch in the last round, but we're all good, survived it. Hopefully no glitches in this round. And before we, well, first of all, I know sometimes some of the attorneys have some preliminary matters or housekeeping matters, as sometimes it's referred to, starting with the plaintiff. Are there any preliminary matters that you would like to bring to the court's attention?
Yes, Your Honor. Two things. In pursuant to Rule 603 and 615, I ask that all witnesses be constructively sworn in and sequestered, barring party representatives.
Yes, that will be invoked. Anything further?
I ask that in closing, both sides be allowed to use any admitted exhibits.
Yes, and I assume there's no objection from the defense regarding that?
No, Your Honor, as long as the exhibits are evidence.
Very well. Anything further from the plaintiff?
The plaintiff is ready to proceed.
I saw there's a question here in the chat about any possible way to give the second chair's ability to privately chat to communicate times. I'm not able to do that on my end. I don't know if anybody else has any of that capability, but you can figure that out. Before we begin, first of all, any preliminary matters from the defense that haven't been addressed yet?
Briefly, Your Honor. First, may we assume that all objections made are made outside the presence of the jury?
Yes.
And also, may we have permission to freely share exhibits that are already admitted into evidence?
Yeah, and I assume the plaintiff has no objection to that since they've already been admitted. I know there's already 3 exhibits that have already been admitted into evidence at this point based on the pretrial order, paragraph 11.
Without objections.
Excellent. Anything further, Mr. Smith?
No, Your Honor. The defense is ready to proceed.
Okay. And yeah, you can drop in times is fine in the chat to everyone. Okay. All right, and before opening statements, let me just remind everyone that you should be in speaker view. The button is in the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. We'll take just a brief break after the opening statements for the scorers to put scores in, and also after the witness presentations before closing, so the scorers can complete that. I'm also scoring, and we'll be commenting here on my iPad that's next to me. I'll be writing some comments, not as much as normal since I'll be listening to the presentations, but we'll be adding some comments as well. With that, is plaintiff's side ready for the opening statements, Ms. Zhang?
Yes, Your Honor.
All right, whenever you're ready, you may proceed.
Follow the actions, inactions, and knowledge On March 24th, 2019, Jessica Marks and her best friend, Morgan Levin, went to Sunny's bar at 9 o'clock, hoping to have a great end to spring break. Action. Over the course of 2 hours, Sunny Mehta, the owner of the bar, served Miss Marks and Miss Levin 3 cans of hard seltzer, 2 beers, an entire bottle of wine, and 2 hard liquor shots. When Miss Marks was leaving the bar, she stumbled on the stairs into Mr. Mehta and almost fell face down to the floor. Even then, all Mr. Mehta did was crack a joke. In action. Mr. Mehta did not take away Miss Marks' car keys. Mr. Mehta did not offer to call Miss Marks an Uber. Mr. Mehta did not stop Miss Marks when she got in the driver's seat. Even when all the evidence will show, he had the knowledge that she was intoxicated. 2 minutes after pulling out of Mr. Mehta's parking lot, Miss Marks swerved off the road into a ravine. In today's case, the plaintiff have to prove by a preponderance of evidence 3 key elements: that Miss Marks was a minor, that she was obviously intoxicated, and that the alcohol was an important factor in her death. First, Miss Marks is a minor on March 24th, 2019. She was only 19. The plaintiff agreed that Miss Marks made a mistake. She should not have drunk underage. But she was just a kid. Second, Mr. Mehta provided Miss Marks with alcohol even after she was obviously intoxicated. Obviously intoxicated means that when Mr. Mehta handed Miss Marks that one last shot, she was slurring her speech, had poor coordination, or was displaying other symptoms of intoxication that you, as a reasonable person, will conclude she's drunk. Not only will the plaintiff bring forth witnesses, but will show you real video footage from the bar. Third, the alcohol Mr. Mehta provided is an important factor in Miss Marks' car crash. A police report concluded that. Follow the actions, inactions, and knowledge. At the end of today's trial, find Sunny's Rooftop Bar liable.
Thank you very much. Mr. Smith, you may proceed with the defense opening whenever you're ready.
Please the court, Ms. Zhang, and members of this jury. There was nothing to see, so there was nothing to stop. See, Ms. Zhang just told you that a young woman named Jessica Marks died in a tragic car accident 2 years ago. That's true. She also told you that Miss Marks was 19 years old and that my client served her alcohol to her on the night of her death. Those things are also true. But when Ms. Zhang tells you that Sunny's Rooftop Bar is legally responsible for her death, well, members of the jury, that's not true. That's not true for one very simple reason. There was nothing to see, so there was nothing to stop. See, in the state of California, bars and restaurants are allowed to serve alcohol, even to intoxicated people. The law only requires a bar to stop serving a customer alcohol if they see that the person is clearly drunk. If that person has lost control of their faculties, if they're slurring their words, or if they have bloodshot eyes, or can't form coherent sentences, if they are what the law calls obviously intoxicated. That concept, obvious intoxication, that's what this trial is really about. And that's going to be a problem for the plaintiff. You see, when the plaintiff sued my client for wrongful death, it became their burden to prove by a preponderance of the evidence, and meaning more likely true than not, that Jessica Marks was served alcohol when she was obviously intoxicated, when she was so clearly impaired, so publicly drunk that a reasonable person would have looked at her and said, that person is too drunk to have another drink. And the plaintiff will fail to prove that today because despite what Ms. Zhang just told you, there was nothing for the employees at Sonny's bar to see to indicate Jessica Marks was intoxicated. So the law didn't require them to stop serving. Today, you're going to hear a lot of evidence and accusations, but I have 3 questions I want you to keep in mind. These questions will guide you to the truth. First, what did the bartenders of Sonny's actually see? You'll learn that the owner of Sonny's bar, Sonny Mehta, visited Miss Marks's table 10 times that night, and that he's trained to spot the signs of obvious intoxication. In these 10 interactions, Jessica Marks was seated, ordering food and drink. She didn't slur her words, she wasn't unable to form coherent sentences, and she didn't act in a way that indicated she had lost control of her faculties. Next, can you trust Morgan Levin? We anticipate that the plaintiff will only call 1 witness to the stand today. And if they're going to rely on the word of that one person to meet their burden, can you really trust that person? You see, Miss Levin's testimony today, his story was contradicted by multiple witnesses from the bar. And that is also going to be a problem. Finally, what does this video really reflect? This video that Ms. Zhang just mentioned. She mentioned you'll get to see a video, and that is true, but the evidence will show that the video was filmed for Miss Marks's Instagram account. And we anticipate there will be a strong reason to believe that Miss Marks's Instagram account doesn't reflect reality. Moreover, you'll hear the testimony that the employees of Sonny's bar never saw actually reflects reality. Members of the jury, at the end of this trial, I'll revisit these same 3 questions, and it'll be clear that Sonny's bar isn't responsible for what happened to that young woman. I'll ask you to recognize that there was nothing to see, so there was nothing to stop. And I'll ask you to return a verdict in favor of the defense. Thank you.
Thank you. All right. So before the plaintiff calls its first witness, I'll ask everyone to switch to gallery view. That button is in the upper right of your screen, and this will allow you to see the attorneys and the witness at the same time. I'll also give our scorers 30 seconds here to enter the scores in for the opening statements now that they're complete. So I'll give word in about 30 seconds to have plaintiff call their first witness. All right. With that, plaintiff may call its first witness.
Your Honor, before I begin with Ms. Levin's direct, may I read stipulation 14 onto the court's record?
Yes.
Stipulation 14 states that the deceased, Jessica Marks, was born on January 20th, 2000. With that, the plaintiff calls Ms. Morgan Levin to the stand. Good afternoon, Ms. Levin. Please introduce yourself to the jury.
Hi, I'm Morgan Levin.
What do you do for a living?
I'm just a student right now, a biology major at UCLA.
Ms. Levin, why are you here today?
I was with Jessica Marks, the night that she died.
Ms. Levin, I know this is hard for you. If you ever need a moment, just let me know, all right?
Thank you.
How do you know Miss Marks?
I was her best friend. She was mine. We met back in middle school, went to high school together. We ended up going to different colleges, but we messaged each other every day.
Were you planning to go anywhere the night Miss Marks passed away?
Yeah, it was March 24th, 2019. We went to a bar together in Malibu, Sunny's rooftop bar.
What did you do at Sunny's rooftop bar?
Just hung out together, ordered some drinks.
Who did you order these drinks from?
From the employees that I saw there at Sunny's. There was one employee there who introduced herself as Sunny, the owner, and the other employee was Frankfurt.
How many alcoholic drinks did you order that night?
Between both me and Jess combined, it was about 8 drinks.
How much of these 8 drinks did Jess have?
I remember Jess having 2 or 3 glasses of wine, 3 hard seltzers, beer, and a shot.
How many of those drinks did you have?
I had 1 glass of wine, 1 beer, and 1 shot.
Even after having those 3 drinks, how clear was your memory of that night?
It was a long time ago, but I remember it pretty well.
Now, I'd like to talk more about Jess. How sober was Jess after she drank all the alcohol?
The more and more drinks she had, it seemed like she got more and more drunk.
How did you know?
I could see it from the way she was acting.
Now, how did you see Jess act?
As the night went on, she got louder and louder. It was slurring her words, not making sense, even stumbling around.
What does she look like?
Her eyes were red and watery, and her face was flushed.
And they kept serving you even as Jess got drunker and drunker?
Yeah, they never stopped serving us that night.
Now, I'd like to talk more about Sunny's. Throughout the night, how many times did Jess talk with Sunny?
Between taking our orders and serving our drinks, I'd say Sunny interacted with us 8 to 10 times.
Did Jess appear intoxicated when talking with Sunny?
Yeah, especially one time she stumbled down the stairs at one point and fell right into Sunny.
Your Honor, permission to put up a timeline as a visual representation of the testimony we are about to elicit?
Okay, you're using it as a demonstrative exhibit?
Yes, Your Honor.
Okay, very well.
After Jess bumped into Sunny, did Sunny say anything?
Yeah, Sunny looked at the other bartender and said, Frankfurt, I think we need to cut this one off.
How did Frankfurt react?
He didn't say anything. He just laughed.
And around what time was that?
That was at about 10 p.m.
And remind me, when did you leave Sunny's?
Me and Jess both left the bar at about 11:45, 11:45.
In the span of these 3 hours, did Sunny appear concerned at how drunk Jess was?
Yeah, she
Calls for speculation.
Any response?
Your Honor, I'm asking for her rational perception as to how Sunny behaved as to Miss Marks' symptoms.
Respond.
Yes.
Your Honor, the question called for this witness's opinion on whether this person was concerned. That directly calls them to testify to the state of mind, which they cannot possibly do.
All right, I think as phrased, the question is seeking speculation. I think more foundation needs to be laid before we can have a lay witness opinion on this issue. So the objection is sustained.
In the span of these 3 hours, did Sunny said anything that indicates his concern?
Yeah, I remember at one point when Sunny was at our table, she pointed at Jessica and said, "I hope this one's not driving."
Did you have any more drinks after Sunny deemed Jessica not fit to drive?
Yeah, we got another round of shots after that.
How many drinks did you have that one final round?
Both of us had a shot.
Did Sunny serve those hard liquor shots?
Yes, Sunny served us the shots.
After Sunny served that one last round of shots, did he ask you to take away Ms. Marks' car keys?
No, she never asked to do that.
Your Honor, I object to the relevance of that statement, Rule 401.
Response?
I am laying foundation as to Mr. Mehta's behavior.
And do you have an offer of proof as to the relevancy that this is leading to?
This goes towards the second element that we are trying to prove, that Ms. Marks was visibly intoxicated and that Mr. Mehta was aware.
May I respond as to that?
Yes.
Your Honor, there's no element of this lawsuit that says Sunny Mehta has any legal responsibility to stop Jessica Marks from driving home that night. Only from stop serving her alcohol as a legal entity when she's obviously intoxicated. Taking away her keys, calling her an Uber, he has no legal obligation to do that. And therefore, any testimony about that is not relevant in today's trial.
All right, the court will see where this leads. There might be some tangential relevancy here, although the court notes the distinction that was just made by Mr. Smith, but the objection is overruled.
After that one final shot, did Mr. Mehta give any indication that he was concerned at the amount of alcohol that you drink?
Well, like I said, that there was that comment where she said she hoped Jessica wasn't driving.
Thank you. Nothing further at this time.
All right, thank you. Cross-examination?
Yes, Your Honor, but before I cross-examine the witness, we ask permission to read a portion of Exhibit 26 onto the record. It's sworn testimony of a woman named Stevie Rieger. And I intend to question Ms. Levin about Ms. Rieger's eyewitness account. The parties have agreed that Ms. Rieger is an unavailable declarant under Rule 804, and her sworn testimony is admissible under 804B1.
All right, any objection to that?
The plaintiff do not have any objection as to Exhibit 26. However, we ask that that Mr. Smith would display the testimony he prepares to read constructively.
That sounds like a reasonable request.
Yes, Your Honor.
All right.
And I'll actually have a co-counsel read the testimony for the jury once we get Your Honor's permission.
Perfect.
May I inquire as to what line Mr. Smith plans on reading?
Yes.
Of course, we can go ahead and pull all those different portions up. Mr. Bueno, get those.
The plaintiff have no objections as to a line displayed on the screen.
All right.
May I proceed with reading these statements?
Yes, you may.
Go ahead, Mr. Bueno.
Can you state and spell your first and last name? Stevie Rieger. Steve Stevir Rieger. Reger. We're here to talk about an incident that occurred on March 24th, 2019. Were you there around 9 p.m. that night? Sonny's was watching the end of the Lakers-Knicks game. They wheel a TV onto the roof when the games are on. Showing Exhibit 2. Did you see this woman that night? Yeah, I saw her on the news. And I saw her on the news the next day. Jessica. Were you concerned about Jessica getting behind the wheel? She was in better shape than her friend. Her friend could barely walk in a straight line to the Uber, but I don't think anyone who drank as much as Jessica should get behind the wheel. How was she walking? Fine, I guess. I don't really remember. I just remember her friend was wobbling like she had been in the ring with a boxer.
Your Honor, may I proceed with my cross-examination at this time?
You may, although the court notes the exhibit appear to say the Lakers Kings and not the Lakers Knicks, although the Lakers Knicks would probably be a more exciting game, but we just want that noted for the record that there is one little minor discrepancy there on the reading of that into the record. But yes, you may proceed.
Appreciate that, Your Honor. Good afternoon, ma'am. On the night you visited Sonny's bar, you and Miss Marks spent 3 hours together before you arrived at Sonny's, correct?
Yeah, she picked me up from my dorm at about 6 p.m. that night.
And over the course of the next few hours, you each drank about a glass of wine. Sure.
That's right.
And you're aware that Miss Marks had an Instagram account, aren't you?
Yeah, I followed it.
In fact, the video we watched a few minutes ago was filmed specifically for her Instagram account, correct?
Yeah, she posted it on there.
Your Honor, permission to share Exhibit 5 on screen for identification, and we're also adding a timestamp to Exhibit 5 that both parties have stipulated to.
Okay, any objection?
No objections at this point.
Okay, you may proceed.
Now, Ms. Levin, you recognize Exhibit 5 as that Instagram post?
It's one of her Instagram posts, yes.
Is this an accurate copy of the Instagram post as you remember it?
The one that she made that night, yes.
Your Honor, the defense offers Exhibit 5.
Any objection?
Without objections.
All right, Exhibit 5 will be entered into evidence.
Ma'am, this picture shows 2 empty bottles of wine, correct?
Yes, it does.
And let's focus on that caption. Jessica wrote, "The start to a good night." You see that?
Yes, I do. It's underlined right there.
But ma'am, you and Miss Marks didn't drink these 2 bottles of wine that night, did you?
No, not both of them.
In the 3 hours leading up to your arrival at Sonny's bar, the 2 of you only drank 2 glasses of wine, not 2 bottles. Isn't that what you said?
That's right.
So Miss Marks's Instagram didn't accurately reflect reality, did it?
I don't know what she was trying to say with it, but those bottles pictured there, that we didn't drink both of those, no.
Well, she certainly exaggerated the truth, right? You didn't have 2 bottles of wine.
But no, we didn't drink both those bottles.
Well, let's fast forward to 11, right?
Fast forward to 11?
You're at Sonny's bar, right?
Yes, we were at Sunny's bar around 11 p.m.
And Miss Marks asks you to take another video of her putting on a show for her Instagram, correct?
Yeah, she wanted to post a video on Instagram.
And in this video, she wanted to look more intoxicated than she actually was, right?
No,
Objection. Speculation.
Any response?
Your Honor, I'm asking Miss Levin if she has any reason to believe that Jessica Marks that night wanted to dissuade her or coerce her Instagram followers into believing that she was more intoxicated in reality than she was on social media.
Any final word?
Then in that case, I switch my objection to more prejudicial than probative.
How so?
In order for evidence to be admitted, all evidence needs to show probative values. However, Mr. Smith displaying the 2 bottles in order to convince the jury that Ms. Marks' videos is not authenticated and is exaggerated, it sways the jury and it distracts from the facts.
Okay, any response to the more prejudicial than probative objection?
Your Honor, there is probative value in the fact that Jessica Marks was not actually drunk in reality, or she wasn't actually showing obvious signs of intoxication. Any attack on this line is highly probative, given that we are here to determine whether she was obviously intoxicated at the bar that night.
Your Honor, may I respond?
Oh yeah, briefly, please.
I am not objecting as towards the fact that Ms. Marks was drunk. I am objecting to the fact that Mr. Smith is trying to exaggerate trying to show that Ms. Marks' behavior in the video was exaggerated.
All right, the court sees some probative value of this testimony and doesn't believe the prejudicial value substantially outweighs that. So the court's going to overrule the objection, but it's without prejudice. If this testimony if elicits an answer that you believe merits that same objection again, you can bring it again. The objection ruling is without prejudice.
Ma'am, I want to switch gears and discuss who actually drank what on March 24th. Because one of the things you're claiming is that you didn't have very much to drink on March 24th. I've got that right?
well, I didn't say that on direct, but I did only have 3, maybe 4 drinks that night.
That's not very much, right?
Not to me, no.
Well, you claim that you weren't drunk at any point that night. That's what you said in your deposition, isn't it?
I wasn't drunk, no.
Sir, ma'am, do you know a woman named Stevie Rieger?
No, I don't think so. I don't know who that is.
Well, that's okay. Ms. Rieger testified that you weren't able to walk in a straight line. If you heard that, you deny that?
Yes.
Ms. Rieger also said that you were wobbling like you'd been in the ring with a boxer. You deny that too?
Yes, that's not true.
But you'll at least admit that Jessica Marks, she was able to walk in a straight line when you left the bar that night, wasn't she?
Maybe at the time we left the bar, not while we were there.
But just as y'all were walking out, just a few minutes after y'all were walking out, she was able to walk in a straight line, wasn't she?
Yeah, she kind of touched her nose and gave herself a sobriety test.
So she gave herself a sobriety test and passed, didn't she?
But yeah, it's kind of a funny little act she puts on.
Well, that's because the truth, Miss Levin, is despite what you told this jury and despite what Miss Marks led her Instagram followers to believe, the truth is that Jessica only consumed 3 drinks at Sonny's rooftop bar that night, isn't it?
That's not how I remember it.
Ma'am, you remember giving a statement to the police at the scene of the car crash, didn't you?
I don't remember it very well. That part of the night was kind of a blur, but I do remember talking to the police.
Your Honor, we're sharing Exhibit 3 on screen now. It's the LAPD report, police report from Ms. Marks's crash. It's already in evidence.
Okay.
Now, Ms. Marks, I want you to read the portion of the report I've highlighted silently while I read aloud. Levin acknowledged that Marks had a few drinks and that Levin had a few also. When I asked what Levin meant by a few, Levin said, I don't know, 3. I read that correctly, didn't I?
Yes, that's what it says in this report.
But now you're claiming she had way more than 3, right?
Yes, she did.
Well, I want to talk about why your story has changed since you spoke to the police. You're aware the plaintiff in this case is Jessica's mother, aren't you?
That's right, Ethel Marks.
And after you spoke to the police, Miss Marks actually threatened to sue you. Isn't that true?
That's true.
Ma'am, you know that getting sued in a case like this could cost you a lot of money, right?
I believe so.
And it was only after the plaintiff threatened to sue you, you agreed to sit down with her attorneys. Isn't that true?
I did speak to her attorneys at one point, yes.
You spoke with Miss Zhang and her co-counsel for 3 hours the day before you were deposed in this case, didn't you?
Yes, I did.
And the very next day at your deposition, you testified it was actually Jessica who drank all those drinks, not you. I'm understanding that.
We both had some drinks, but Jessica had the majority.
And it was only after these 3 hours you spent with Miss Zhang and her co-counsel that you changed your story to Jessica having way more than 3 drinks, correct?
When I was asked that question, when my deposition was being taken, yes.
And when we questioned you at your deposition about whether your 3-hour meeting with plaintiff's counsel is why your story changed, you claimed you couldn't remember any specifics from your 3-hour-long conversation from plaintiff's counsel from the day before. I've got that right?
I just remember they told me to tell the truth.
Redirecting you to my question, when we asked you at your deposition, you claimed you couldn't remember.
Time's expired. Any redirect?
Yes, Your Honor. Ms. Levin, Mr. Smith asked about what you don't remember. Let's talk about what you do remember. How many drinks did you watch Ms. Marks order?
I watched her order a bottle of wine, 3 hard seltzers. She ordered a beer and she ordered a shot.
And did she display any symptoms of obvious intoxication after having these drinks?
Objection, Your Honor. This is outside the scope of the cross-examination. Ms. Zhang has already asked these questions on her direct. This witness has already given the exact same answers.
Any response, Ms. Zhang?
Your Honor, I'm asking specifically whether Ms. Marks can walk in a straight line and how did she act physically? I've only asked for facial symptoms and the sound Ms. Marks projected on direct. In addition, during cross, Mr. Smith asked about whether Ms. Marks seemed drunk, and that opened the door to my line of questioning.
Okay, I think that asking about obvious intoxication does relate to some of the testimony that was elicited on cross, so the objections overruled.
Can you describe Ms. Marks physically after she had those drinks?
Yes, from what I could see, her eyes were red. She was loud. She was stumbling, and she just didn't make a lot of sense to me.
Thank you. Nothing further at this time.
All right, and we have time expired on the other end, so this witness may be excused. And with that, the defense may call its witness.
Your Honor, the defense calls Sunny Mate. Can we proceed?
You may proceed.
Good afternoon. Can you tell us your name?
Good afternoon. My name is Sunny Mehta.
And are you the owner of Sunny's Rooftop Bar as of March 24th of 2019?
Yes, I did own that bar.
Ms. Mehta, why don't you tell this jury a little about yourself?
Yes, I would say I'm an entrepreneur. I have been living in LA my entire life, and actually I'm started a new business. I'm making jewelry now.
And as the owner of Sunny's Rooftop Bar, are you familiar with the law as it relates to serving patrons who are obviously intoxicated?
Of course I do. I know it is absolutely not allowed, and I really try to be careful about not serving people who are obviously intoxicated.
Have you received training on how to recognize a patron who's obviously intoxicated?
Yes, I do. There's actually the state required responsible beverage service course that I take. It has to be updated every 3 years, and there's an exam I have to pass.
And had you taken and passed that exam as of March 24th of 2019?
Yes, of course.
And was all your certification current on March 24th of 2019?
Yes, it was.
So what are some of the things you look for to make that determination?
I look for slurred speech, loss of motor control, flushed cheeks, people who are loud or not making sense. But really, it just comes down to the person. Everybody behaves differently, and I go on a case-by-case basis.
Did you serve alcohol to Jessica Marks on the night of March 24th of 2019?
Yes, I did.
Do you recall how many times you had an opportunity to observe her that night?
Yeah, I would say, they had around 4 to 5 rounds, so I would say I came 8 to 10 times, spread out over those 3 hours.
Can you describe what you observed about her condition when she arrived?
When she arrived, she looked fine to me, sober.
How many times did you attend her table to take or deliver her orders?
Like I said, 8 to 10 times.
What physical activities were you able to observe or engage in?
Well, I didn't see her do many physical activities. She was sitting down most of the time.
And what were you able to hear her say?
She ordered drinks for me, so I was able to hear her drink orders.
So in all of those interactions, what did you hear about her or about her speech?
She sounded fine. She didn't slur to me or anything.
What did you observe about her eyes?
Again, they looked fine, clear, normal.
What did you observe about her coordination?
Again, I didn't see much because obviously she wasn't running around the bar or anything, but from what I saw, she looked fine.
Did you observe anything or hear anything that led you to believe she was obviously intoxicated?
No, absolutely not. If I had, I would have cut her off. I do it all the time. I'm a bit of a people pleaser, so I just say, sorry, but I think you've had enough.
Did you observe her stumble down the steps as Morgan Levin testified she did?
I heard that, but I didn't see it.
Did you make the statement that, Frankfurt, we might need to cut this one off?
No, absolutely not.
Did you say that you hoped she wasn't driving?
No, I said that about Morgan Levin. Morgan Levin was the one who appeared intoxicated to me.
Did you see Miss Marks as she was leaving that night?
Yes, I did.
And what did you observe about her condition at the time?
She seemed almost sober. I mean, maybe a little tipsy, but really nothing out of the ordinary.
Now, Miss Levin testified that Miss Marks was walking in a straight line as she was leaving, as if she was performing a field sobriety test. Did you hear that?
Yes, I did. I didn't see Miss Marks leave, but that sounds about right from what I saw.
Based on your training as a bar owner and your certification from the state of California, what does a person's ability to walk in a straight line, as in a field sobriety test, show you with regard to the things you are trained to look for in evaluating whether that person is obviously intoxicated?
It tells me that they have good motor control.
Thank you, Ms. Mehta. I have nothing further, Your Honor.
All right, cross-examination,
Yes, Your Honor.
whenever you're ready.
Ms. Mehta, earlier you said something really interesting and I wrote this down. You said, I didn't see Miss Marks leave. Is that your testimony today?
I'm sorry, maybe that was mistaken. I did see her leave the bar, but it wasn't like I was watching her get into her car or anything.
All right. In 2018, Sunny's bar was subject of criminal charges, right?
Yes, that was an unfortunate incident.
One of your employees forgot to check the customer's ID.
Yes.
Objection, Your Honor, as to relevance?
Response?
Your Honor, if I may have an offer of proof.
Yes.
The employee who forgot to check the ID was Frankfurt, and Frankfurt served Miss Marks.
May I respond?
Yes.
Your Honor, if the relevance of this evidence goes to purposes of propensity, then I shift my objection to improper character evidence under Rule 404B. They can't prove that because Sonny's Rooftop Bar did something in the past, that they were more likely to do it on this occasion.
Any response?
There is an exception to that rule in which this becomes a business habit. And this is what we are trying to establish in this line of questioning.
I'm going to give a little leeway and overrule the objection to see if it can establish as a business habit. So the objection will be overruled, but without prejudice to re-raise it if the foundation hasn't been laid.
Now, Frankfurt was the one who forgot to check the ID.
Yes, that's right. He was so torn up about it.
And you mentioned that all of your employees have trainings at your bar.
Yes, that's true.
I would like to talk more about that training. There is only one step in that training.
Well, first off, they have to take the responsible beverage service course that's required by the state. And then, I have a little training day where I ask them to card anyone who looks under 45.
You claim your employees passed the responsible beverage service course.
Yes, they did.
And you knew this because your employees told you they were.
Yes, they did.
You do not have any evidence that they passed the course.
I have their word, and that's enough for me. My employees are all good people.
That's right. You've never asked to see your server certificates.
No, I didn't need to.
Now, I would like to talk more about Miss Marks. You remembered Miss Marks.
At this time, I re-raised the objection regarding all testimony related to the past prior bad acts of Sonny's Rooftop Bar.
Okay, any response to that?
I am asking to which line Mr. Smith is objecting to.
All testimony referencing any prior actions, such as the 2018 conviction of Frankfurt Johnson, the citations.
Your Honor, may I respond?
Yes, of course.
It is the plaintiff's position that we have established forgetting to check ID as a regular business habit.
May I respond as to that point, Your Honor?
Yeah, briefly.
Your Honor, a regular business habit is something that is so common that someone might forget. Forgetting to check someone's ID is not a regular business habit, and they've showed no evidence that that is the case with Sonny's Rooftop Bar. Regular business habit would be something like cleaning up every night, or, for example, something so common that it is done every day. But to say that they just regularly conduct their business that way is not evidence to overcome the propensity argument that because they acted this way in the past, they act that way so regularly that they're allowed to bring that evidence forth and say that that's how they're acting in today's situation.
May I respond?
Yeah, final word.
It seems that Mr. Smith's argument is that the plaintiff is trying to use the prior bad act to prove that, in this case, the employee forgot to check the ID. However, the plaintiff is just using that to lead toward the training that Ms. Mehta has conducted for her employees.
Even though I said final word, I'll allow, based on that new argument, I'll allow Mr. Smith one final word here.
Again, Your Honor, I would also object that any testimony related to the IDs of Sonny's Rooftop Bar that night is also not relevant in today's trial. The only thing that we are here to determine is whether or not they served them alcohol while they were obviously intoxicated. It doesn't matter that Sonny's Rooftop Bar served them while they had a fake ID to get them into the bar. It doesn't matter if they've done that in the past. It doesn't matter if they did that in this instance. All that matters is whether they served them alcohol while they were obviously intoxicated.
All right, the court's gonna sustain the objection and strike any testimony that was given related to the previous incident that was testified about.
The plaintiff asked to clarify, do the testimony regarding Ms. Mehta's training still stands?
The testimony regarding the training does still stand, yes.
May I continue as my line of questioning?
Yes.
Ms. Mehta, you remembered Ms. Marks to be around 5 feet tall.
Yes, that's right.
You remembered Ms. Marks to be around 110 pounds.
You know, I don't like to guess people's weights, but I would say she was approximately that.
You assume that she and Miss Levin are finishing their drinks.
You know, I don't exactly remember if they were completely finishing them or whether they weren't, but I do know they kept ordering.
Now, at the time, you assume that they were finishing their drinks.
Yes, I suppose so.
Now let's talk about what they ordered. Miss Marks was at your bar for around 3 hours.
She was.
Over 3 hours, you served her and Miss Levin 1 bottle of wine.
That's right.
You served them 3 cans of hard seltzer.
Yes, that's true. Although hard seltzer doesn't actually have much alcohol content. It's pretty weak.
You served them a pint of draft beer.
That's right.
You served them a pint of beer.
Yes, that's true.
And you served them hard liquor shots.
Yes, those were the green tea shots. They were special that night.
At the time, you think Miss Levin drank about half of the drinks.
Yes, I would say so.
You are not concerned that a 5 feet tall woman is having all that drink.
No, like I said before, alcohol can affect people very differently. I go on a case-by-case basis.
You're not concerned that a 110-pound woman is having all that drink.
No, I wasn't. She looked fine.
Even after having all those drinks, you claim she did not get more drunk over the night.
I mean, maybe slightly drunk. She was pretty sober when she came in and not perfectly sober when she left, but I didn't see much change.
Permission to display Exhibit 10 outside the purview of the jury?
Yes.
Ms. Mehta, do you recognize this woman in the video still?
Yes, that's Jessica Marks.
Plaintiff offers Exhibit 10 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 10 will be admitted.
Can we play Exhibit 10 for the jury, please?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Thank you. Now, Ms. Mehta, you would not say that Ms. Marks is obviously intoxicated in this video.
I wouldn't say she's obviously intoxicated. You know, if I had seen it that night, I might have been concerned, but I didn't see it.
In fact, you would not say she sounds drunk in this video.
I wouldn't say she's drunk, maybe a bit tipsy.
In fact, you can't even tell from this video that Ms. Marks had been drinking.
I don't know about that. I mean, you can see the drinks in front of her. Like I said, I would have been concerned, but I didn't see her behave this way.
At 11, you discussed with Ms. Marks and Ms. Levin, who was driving home.
Yes, I did. I was concerned about Miss Levin.
Thank you. Nothing further at this time.
Thank you. Any redirect?
Yes, Your Honor, but before, may I ask how much time I have left for redirect?
Yes.
2:48. Okay. Now, Miss Levin, let's go back to that video that Miss Zhang just asked you about. Did you see that video being shot?
No, I did not.
Compared to what appears in the video, I want to ask you about the reality of what you observed that night. Did you ever hear her slurring her words?
No, I did not.
Did you ever hear her having problems with her coordination?
No, not at all.
Did she ever not make sense?
No, I only heard her ask for drinks. She always made sense to me.
And did she ever walk in a manner that was abnormal?
No, she didn't.
So in other words, she was acting in a sort of reality different from the video posted on Instagram, right?
You could say that. I did not see her behaving that way that night.
Thank you, Ms. Mehta. Nothing further, Your Honor.
All right. Any recross examination?
No recross, but Your Honor, may the plaintiff read stipulation 18 onto the record?
Yes.
Exhibit 10 was posted to Jessica Marks' Instagram account at 11:11 p.m. on March 24th. And before the plaintiff rests our case, may the plaintiff also read Exhibit 23 into evidence.
That's the stipulated fact based on the pretrial order number 23, or is there an? Yes.
Exhibit 23, and may the plaintiff read the second to last paragraph onto the record.
Yes, based on the stipulated fact, it's pre-admitted and may be used at any time. I mean, is there any objection to this?
Your Honor, it's the defense's contention that this sort of evidence should have been brought in, or it's already pre-admitted, but it should have been read onto the record during the plaintiff's case in chief.
That is true. This is the defense's case in chief. It is already pre-admitted. The courts then agrees, unless there's any response. It seems like this, reading into evidence, different exhibits would have been needed to be done before the plaintiff rested.
No, Your Honor. Then the plaintiff withdraws this exhibit.
All right, very well. It is pre-admitted, but again, we won't allow the reading in since this is the defense's case in chief. With that, are we ready to proceed to closing arguments?
Your Honor, the defense rests.
Excellent. And before we begin closing arguments, we'll give scorers and myself just 30 seconds here to wrap up witness scoring to maximize time here. All right, we may proceed with closing arguments, first with the plaintiff. So whenever you are ready, you may proceed.
Your Honor, first I ask that any time I have left for my closing be reserved for rebuttal.
Yes, that is fine, and I'm sure we'll have that posted here in the chat after you complete your closing.
May I proceed?
Yes, you may.
Follow the actions, inactions, in knowledge. You've heard the defendant, Sunny Mehta, served Jessica Marks and Morgan Levin 3 cans of hard seltzer, 2 beers, an entire bottle of wine, and 2 hard liquor shots. Ms. Mehta said to her employee, "We might need to cut this one off." But he never did. He did not refuse to serve Miss Marks alcohol, not even when she had the knowledge that Miss Marks was intoxicated. Through the testimony presented in court today, the plaintiff have proven the 3 key elements. Miss Marks was a minor. She was obviously intoxicated, and the drink Miss Mehta served was a significant factor in her death by a preponderance of evidence, more likely than not. Let's review each of the elements again. First, Miss Marks was a minor on March 24th, 2019. the night of her death. She was only 2 months past her 19th birthday. She had hoped, but she never did walk across the graduation podium, go to law school, to pass the bar, to stand here and make her first opening or closing. This is because of the second element. Miss Mehta provided Miss Marks with alcohol, even after she was obviously intoxicated. Miss Levin, who sat right in front of Miss Marks for the entire night, told you that Miss Marks got drunker and drunker. Let's start with sight. Miss Levin told you that Miss Marks' eyes were red and watery. Sound. Miss Marks was loud. She was slurring her words, and those words did not make sense. Movement. Miss Marks was not coordinated, and she bumped right into Miss Mehta and almost fell down the stairs. And Miss Mehta knows this because she acknowledged we might need to cut this one off. But she did not. She claimed that it was Miss Levin, not Miss Marks, who was obviously intoxicated. But members of the jury, let's look at the evidence. Miss Levin, she admitted that she had 3 drinks. But she also remembers that night because for 3 hours, she sat right in front of Miss Marks. Members of the jury, Miss Mehta claimed that Miss Marks was not intoxicated, not even in Exhibit 10. Let's play this video again.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Today, Mr. Smith stood in front of you and asked whether Miss Marks' actions was exaggerated or not. But members of the jury, regardless of whether it is exaggerated for Instagram or not, one thing is clear. You heard Miss Mehta testify that Miss Marks' state in the video would not be obviously intoxicated. In fact, you heard her admit that she would not deem Miss Marks as drunk. Members of the jury, if this in the video is not obvious intoxication, what is? Third, the alcohol from Sunny's is an important factor in Miss Marks' car crash. Miss Levin told you that after Miss Marks stayed in that video, Sunny's bar continued to serve her more alcohol, more hard liquor shots. And after pulling out the driveway, Miss Marks crashed. Today, we have proven to you each of the elements. In a minute, The defense will try to convince you that Miss Marks died because she was negligent. The members of the jury, Miss Marks made some bad decisions on March 24th. We agree she should not have drunk underage. We agree she should not have driven. The plaintiff also agrees that Miss Mehta, who is trained and certified in recognizing intoxication, should not have served Miss Marks more alcohol. Find Sunny's Rooftop Bar liable.
All right, thank you. Defense closing argument whenever you are ready.
Please the court, Mr. Zhang, and members of the jury. There was nothing to see, so there was nothing to stop. Remember the evidence. Sunny Mehta had the opportunity to observe Jessica Marks 10 to 12 times that night. When she arrived, when she took her orders, when she delivered her orders, and when she left. No one disputes that when she arrived, she appeared sober. On the occasions when he took her orders, she was sitting at a table. She was moving around, sitting. And what she observed about her as she sat at the table and gave no indication that she was obviously intoxicated. No indication she had lost control of her faculties. And when she heard her speak, she did not slur her words. You saw the video. And while Sunny Mehta did not observe Miss Marks make the video, remember how she sounded in the video. It was a little quirky, sure, but it was a production, an act for Miss Marks's Instagram followers. And Instagram is not reality. It wasn't reality when Jessica Marks posted a photograph of 2 empty wine bottles, when in fact Morgan Levin and Jessica Marks had only a glass or 2 apiece before they left the Airbnb that night. And it wasn't a reality when Sunny Mehta saw her at the bar that night. But even in the video, you heard Miss Marks speaking in complete sentences. You heard her pronounce her words properly. Her words were not garbled or mumbled or incoherent. That's what Sunny Mehta told you about how she sounded when she took her orders. She wasn't slurring her words. She didn't sound drunk. Sure, hindsight is 20/20, but what we know now is not the reality of what Sunny Mehta knew then. And you must decide this case not based on what you know now, but instead based on what Sunny Mehta observed then, on reality, not Instagram. So the only other time that Sunny Mehta observed Jessica Marks was when she was leaving that night. She told you that she observed her walking without a problem. Is that right? How can you know? You can know because that's what Morgan Levin told you. Remember, Morgan Levin testified that Jessica Marks walked in a straight line, and she touched her nose with her finger. Members of the jury, that's what was observable for Sunny Mehta. Walking in a straight line does not show loss of control, does not show obvious intoxication. Touching your nose with your finger and walking in a straight line doesn't show obvious intoxication. And now we know that Jessica Marks had a blood alcohol content of 0.16. But you must decide this case based what, again, not based on what we know now, but about what we knew then. Because that's what Sunny Mehta knew then. What Sunny Mehta knew was that Jessica Marks did not appear obviously intoxicated as she sat at her table. And as he heard her order, and as he left the bar that night, as she was able to walk in a straight line and touch her nose with her finger, in other words, able to pass a field sobriety test. This is evidence about what Sunny Mehta knew and observed then. Now, Morgan Levin did tell you that Jessica Marks stumbled down the steps and into Sunny Mehta. Sunny Mehta denied that this even occurred, and she denied that they needed to cut her off. As she did say that she hoped one of them wasn't driving. But she said that to Jessica Marks about Morgan Levin. That's not what Morgan Levin would have you believe, though. And that's because it was Morgan Levin who was showing signs of obvious intoxication that night. Morgan Levin denies that, but remember, you also received evidence from another customer of the bar that night, Stevie Rieger. Stevie Rieger testified in a deposition, he couldn't be here with us today, that Morgan Levin was clearly drunk and that she was in no condition to drive. Not only that, but Jessica Marks was Morgan Levin's best friend. And the truth is, members of the jury, Morgan Levin was here today to do whatever she could to help Jessica Marks' mother win this lawsuit. That's why she was here, to convince you to believe that Instagram is reality, and that she wasn't the one who was outwardly drunk, and that Sonny Mehta should have seen the signs that weren't even there to be seen. Members of the jury, no parent should ever have to experience the loss of a child. As tragic as this case is, the judge will soon charge you. And he will tell you that you cannot decide this case based on empathy or on emotion or because you feel sorry for Ethel Marks's profound loss. And as I said, you cannot decide this case based on a hindsight because Sonny Mehta, well, she didn't have the benefit of hindsight that night. You must decide this case based on the law, which holds a bar liable only if it serves alcohol to a person who is obviously intoxicated at that time. There was nothing for Sonny Mehta to see that night, so there was nothing for her to stop. Find the bar not liable. Thank you.
Thank you. And do we have any time left for the rebuttal argument from plaintiff?
The plaintiff do not have a rebuttal argument.
Okay. All right. Well, before we begin comments, we'll submit these ballots here. We'll wait for confirmation that all have been submitted and no technical glitches or anything. So I'll await word from our bailiff on that, and then we'll resume with some brief comments. All right, we are good to go. So outstanding round. Before I give some final comments, let's hear from our scorers. First, let's have Mr. Lopez.
All right. Hi, everyone. My name is Hugo Lopez. I practice business litigation law out in Orange County. I've been doing that for 5 years. I scored mock trial at all levels, high school, college, all different formats. I used to coach high school mock trial as well. Congratulations to you guys. This was a fun round. I truly enjoyed it. Great job. I know it's been a long day, so I'll keep my comments very short. Just to the attorneys, both Ms. Zhang and Mr. Smith, great job starting with your theme up front and then opening your closing statements with it, just to kind of refresh us as judges what it was, kept it in our minds. From Ms. Zhang in particular, I just like the demeanor and the composure you had throughout the proceedings. It was you were always very composed, easy to follow. So it made my job easy as a scorer to listen to you. For Mr. Smith, I enjoyed your cross of Morgan Levin. I thought you did a great job with your line of questioning, kind of setting her up and then finishing strong, establishing her bias and calling into question her credibility and her motives for offering the testimony that she was offering. And then lastly, to the witnesses, I thought you guys did a good job of providing great testimony to your attorneys and to us scorers and kind of staying composed under pressure on cross. So good job to everybody, and good luck on your last round tomorrow. Thank you.
All right, great comments. And then let's see, we have Mr. Johnson as our other juror and scorer here.
Yes, thank you. So congratulations on being here. If you weren't good, you wouldn't be here. Well done today. I enjoyed it as well. I just want to echo that. If you have we did a good job having the theme and following it throughout. If you have a good story, you will find things like tone, timing, and emphasis. It will naturally go there to where you want it to be. I think the two things that will help, if you like Gallup poll, there's been a lot of research on what people remember and what they don't. If you look at that kind of information and that data, they remember two things. One is when it builds up to something intense, they'll remember that moment. They'll also remember the last thing that you end on. Okay, so those two areas are very important for you. And the last little bit is to, a lot of this is a learning opportunity for make sure that you go back and review and keep getting better. Congratulations again. Have a great evening.
Outstanding comments, and I totally agree with everything said. Really great job. I mean, first of all, my name is Jeff Blank, and I have judged these rounds at Gladiator for probably about 4 or 5 years now. Presided over, semifinals a few years ago. I've scored the final round and all that, and coach a high school team for the last 10 plus years, and practice business litigation. And actually have a lot of trials coming up with they were on hold during the pandemic, and now they've all been reset. So we'll be doing what you guys are doing in upcoming weeks and months here. So took some notes to get some tips from you guys, but no, this was a good round. I mean, first of all, the energy level, I know third round of the day, I don't know if you've already been an attorney earlier in the day or witnessed whatever it was, it's a lot to switch roles and then be in your third trial of the day. That's a lot. And I didn't sense any fatigue. I know I have before in scoring, this day, and even, high school mock trial at certain tournaments. And so really, hats off that all of you, your preparation showed and you didn't tire at all from the earlier rounds and switching roles. And there was a lot of really good, exchanges where I know you just met your witness like right before the trial to kind of go over the questions and everything. And it's not much time to prepare, and there wasn't really any hiccups there. I agree with the comments about, you want to end the examinations on a crescendo. So I always just think about that final power punch on cross and ending direct on a, dramatic moment in testimony. But great carry through on all the themes, and I agree on all the comments made. It was a good job by, Mr. Smith to remember the objection. It said, without prejudice, a foundation is laid. Usually a lot of times you see attorneys forget to then move to strike later, but that was a good job of bringing back that, objection and showing that you were in the moment. Both Ms. Zhang and Mr. Smith did a great job on the objections, even switching them kind of midstream a couple of times. And that's good. And that you see that at real trials too. A lot of times different arguments are being made and you're listening and responding and making different objections and responding to those objections. So I thought both of you did a really good job, and the witnesses were, really good portrayal. It was fun to watch. It was really realistic portrayals. It felt like, a real courtroom. And again, the energy comment, it didn't seem like anyone was tired at the end of the day, because I imagine both witnesses have at least been an attorney in one round earlier today, and that can be exhausting. So I didn't sense that at all. So great job. Good luck tomorrow, and congratulations on, being some of the top high school mock trial attorneys and students in the country. I'm hoping you're really enjoying the program, and you're all going to, use these skills in any walks of life, whether, you go on to be attorneys or, pursue other careers. So congratulations to everyone. And with that, we are adjourned. You're welcome.
Thank you so much.
You.
Thank you.